ate moose meat for dinner, bought it from a Mi'kmaq man who came into town. So what it was showing was there was clearly trade outside truck houses where people were selling, hunting, fishing, and gathering to earn livelihood dollars. And that was Reverend Seacomb's diary is what the Supreme Court started their decision off with when they brought it down in 1997. Now, the Supreme Court was an interesting thing because we're here to talk about livelihood, but nobody ever argued livelihood in the case. When the case was brought forward, we were arguing that the Mi'kmaq had a commercial right to the fishery. What happened in the Supreme Court, and I think the reason they went the way they did, is there were interveners who were arguing that commercial meant full bore everything. That they could be out with as many boats as they wanted, fishing as much as they wanted. And I think the Supreme Court became concerned that there was no built-in check or balance into that scenario. I think they felt that if you looked at an Aboriginal right for food, they felt there was an innate check and balance. You can only take as much as you can for your own food needs, and it can be quantified. I think in the Supreme Court's mind, they felt that out-and-out commercial has no inherent limit. You fish, and you fish, and you fish till you can't fish anymore, to sell it off to whomever. So it was the Supreme Court itself that invented this term called moderate livelihood. Crown didn't have that in there. We didn't have that in there. It was the court. And I think they did it to say, here's how we'll create an inherent limit within the decision. Once a moderate livelihood is figured out, it'll all work. Clearly, it is not the easy concept they apparently felt they were putting into the case. When the first decision came down, as Jane said, we had spent all of our time just focusing on winning the case. That's all we really thought about. You know, we need to win this case. This is what's going to take the whole notion of Aboriginal and treaty rights to a level where it needs to be. And when it came down in our favor, having lost all the way up through, from my aspect, everybody else was ecstatic and happy. When you're the lawyer on the case, it's just more relief. It's just absolute relief that it came out well. We had never anticipated what has now become known as Marshall II. But we have to talk about it because it's become the companion to what the Marshall case is. What Marshall II really was a few months after the Marshall case had come down, and clearly there was societal disruption as a result of the case. A non-native fishing organization made an application to the Supreme Court, and they said, look, Supreme Court, you've created mayhem, you've destroyed society, you need to reevaluate what you said in the Marshall case. So all of us put in our arguments, we put in our briefs and all the rest of it, but really what we were arguing at the time was, A, there was no need to reopen the Marshall case because the Marshall case seemed pretty clear to us, and you didn't need any clarification. Second thing we said is, this is not how you do things in the legal system. Just because you're unhappy with the decision doesn't mean you get to make an application and have the court do a do-over. The Marshall case is what it is. So that's what we were all arguing about. When Marshall II came down, I think it was a disappointment, certainly to Bruce and I think to the Mi'kmaq in general, because the court denied the application. They said, right, reopening a case is not what you do, and we're not prepared to do that. And then went on for how many pages to analyze what they had said in Marshall. So it's almost, we don't do that, but here we go. And the problem I have with it, and will always have with it, is none of us had the opportunity to put in arguments or submissions about what Marshall II had to say. That was simply the Supreme Court making its own determinations about what they wanted to put in there. The Crown didn't have submissions about that. We didn't have submissions about that. Everybody had been arguing about whether or not you should even reopen the case. But Marshall II is Marshall II. And as one judge told me in the logging case later on, I understand, Mr. Shiley, you're not happy with it, but the Supreme Court has said what the Supreme Court has said. And if I have to listen to you or I have to listen to the Supreme Court, I guess it's going to be the Supreme Court. So that was an understanding I had that day in court, that it was going to be the Supreme Court has said what the Supreme Court has said. But I think we'll always look back at what happened in Marshall II and wonder if that had not been put out, would things have been easier? But that'll finally get me to my last part, and then the ramblings of an old guy who remembers an historical event are over. I think, as I look back at it in retrospect, nobody was prepared for the aftermath of the Marshall case, bar none. Department of Fisheries and Oceans and the Crown, as they told me later on, were so convinced that Junior's case was going to be unsuccessful, they never even contemplated a plan B. Ordinarily, in something as big as DFO, you'd think you'd have a few people just in some back room somewhere coming up with a possible contingency plan just in case. But they had a meeting literally the week before Marshall came down, and the upshot of the meeting was, don't worry, we're going to win the case. We don't have to change a thing. They were completely and utterly unprepared. And I've got to say, on our side of the equation, we were a bit naive. We had spent all of our energies and all of our time thinking about nothing but winning the case. If somebody had asked me back in those days what will happen the week after, I wouldn't have had an answer. And I think we were naive in the sense that if the court comes down and says the right exists, well, that's it, isn't it? Everything will just fall into place. Everybody will be able to go out, exercise their rights, and do their thing. We never had a plan ourselves. We'd never gotten together and said, maybe we should come up with something that will be put into place. Maybe we should have our demands ready to go once these things happen. But we'd never been there before. We'd never done anything like this before. Sometimes you get so involved in these things, you lose the possible magnitude these things can have. And so in those days just following Marshall, I just remember bedlam. I just remember bedlam. And it wasn't just the bedlam on the water in places like Burnt Church and Yarmouth. It was just bedlam politically. I remember, I'll never forget the meeting we had at the Hotel Nova Scotia with Minister Dollywall of Fisheries and Oceans, and a federal minister sitting up at a front table saying, I have no clue what to do. Do you have any suggestions? Because I don't know what to do. And it was a realization, if we ever did it all over again, if I had a chance to go in the Wayback Machine and do it over again, would have spent more time thinking about a plan ahead of time. And the other thing that I think I've grown to understand over the last 20 years is the Marshall case and what Junior and Jane brought forward and where we are today was so much more than just a decision respecting access to a livelihood fishery. The case itself has opened up innumerable questions for the Mi'kmaq communities going forward. Not just about commercial fishery, but about what is the future of Mi'kmaq communities in Nova Scotia. What is the relationship between Mi'kmaq communities one to another? What is the relationship of individual community members with their band? What is the relationship of the Mi'kmaq economically between themselves and the wider world? Ultimately, what is the self-determination of the Mi'kmaq going forward as a nation, as rights holders, and as communities who are poised to start making their own decisions? These are all aspects and aftermaths of what the Marshall case was all about. So I am pleased to have been able to speak with you. I know many of you for years and years and years, and it was just an honor and a privilege to play whatever part I could play in where you're going in the future. So, Walario.
Thank you, Eric. And now, Eric, you have the right to remain silent for the rest of the conference. You have right to attorney. Never gets old, right? Good times, good times. We're going to kind of plow right through it. It's just amazing, amazing what's happening here, and the story, how it continues. And you can hear a pin drop. That's how amazing these speakers are. And what we're going to do is I'm going to invite and introduce the next speaker. And at this time, before the speaker comes up, or as the speaker I'm going to give you guys the opportunity. There are pastries. There's treats or pastries and snacks available. So, but I don't want to stop this momentum. It's truly amazing. So if you need a break, this is a quick opportunity while I'm doing the introduction, because we want to keep it going, and it's truly amazing to have these great speakers in the room. So our next presenter at 12:15, if you're following our agenda, is one of my mentors, Senator Dan Christmas, the very first Mi'kmaq senator. Senator Dan Christmas, Senator Christmas served in various leadership positions for the Mi'kmaq Nation. After serving 5 years as a band manager for Membertou, and also senior for Membertou, Senator Christmas also worked for the union for 15 years, and the last 10 years as its director. He was actively involved in the recognition and implementation of the Mi'kmaq Aboriginal and treaty rights in Nova Scotia. Senator Christmas held a position of senior advisor for Membertou and assisted chief and counsel in his management team with its day-to-day operations, and served as an elected councillor for 18 years. Senator Christmas has been active in a number of international, national, provincial, and local agencies in a wide range of fields, including in Aboriginal and treaty rights, justice, policing, education, human rights, business development, and the environment. Now, on December 2016, Senator Christmas became the first Mi'kmaq senator to be appointed to the Senate of Canada. How about a big round of applause to my mentor and neighbor, Senator Dan Christmas.
Well, good morning, everyone. It's good to be here. So I just want to thank the previous speakers. It was pretty powerful. It's a good way to remember this special day. I still can't believe it's 20 years already. I remember clearly on September 17, 1999, we were all sitting in a hotel room in Halifax with a group of chiefs, and we asked Eric Shiley and Bruce Wildsmith that once the decision was released, that they would call us at the hotel and let us know what the decision was all about. So I remember that conference call. I remember the joy and the excitement among all of us that were waiting there. We couldn't believe we won, but we couldn't believe how big we won. So I always remember that moment. And I would say that was probably the high point of this case, because after that, and even 20 years later, we really haven't had the full realization of that court decision. So I know we have a short space of time between now and lunch, but what I was asked to talk about was Bill C-68. It's an amendment to the Fisheries Act, and the official name of C-68 was an act to amend the Fisheries Act and other acts in consequence. This was passed in 2018 by the House of Commons. It came to the Senate earlier this year, and it was passed in the Senate this past June. The Governor General gave the royal assent to the bill on June 21st, National Indigenous Day, and then the bill finally came into force just a few weeks ago, August 26th. It's a long document, it's about 66 pages, English and French. I would never wish anyone to read that because it's painful and it's difficult and it's very confusing, and I think only lawyers can probably make sense of it. The reason I know a little bit about it is because when the bill came to the Senate, they were looking for a senator to sponsor the bill. It's no problem in the House of Commons. It's usually the minister responsible. In that case was the Minister of Fisheries. But in the Senate, it requires another senator. So I was asked and approached, and I agreed that I would be the lead senator in bringing this bill through the Senate. So first of all, before I get into the details, I just want to do a quick refresher on how laws are passed in the Parliament. And laws can be introduced either in the House of Commons or the Senate. Those that are introduced in the House of Commons begin with a C, like C-48. It started in the House of Commons. If a bill begins with S, that means it started in the Senate, like S-3, for instance, the bill that enacted the registration provisions in the Indian Act. Once the bill is introduced in the House, its first reading, all they say is, here's the bill, it's received. The second reading is where the first debate begins, and it's really about a debate about the principles of the bill. It's quite standard after all the senators or all the MPs who have wanted to speak have spoken. The next critical step then is referred to a committee. So either in the committee in the House of Commons, and in the Senate, it was referred to the Fisheries Committee. And this is where really the work happens. This is where the committee can call witnesses. I think in our case, we had 8 meetings. We called 55 witnesses. And after you call the witnesses, then you go through all the possible changes that you want to make to the bill. It's called clause-by-clause review. I remember we had 2 full sessions of that. And then finally, the committee makes a report back to either the House of Commons or the Senate. And finally, you get to third reading, and this is where the final vote happens. And once all the MPs or senators have spoken, then it finally goes to a vote, and then the bill is decided upon. So once it goes through the House of Commons, it follows that first, second reading, the committee process, the third reading. In this particular bill, it was passed June of 2018 in the House of Commons. When we came back in the fall, this time last year, then this bill went through all the same steps except in the Senate. And so when finally the bill was passed through the Senate, if there is a difference between the bill in the House of Commons and the bill in the Senate, before it becomes law, both bills have to be identical. If there's any changes made by one house or the other, you have to basically allow the government, meaning the House of Commons, to decide on the final version. And so it was sent back to the House of Commons, and finally, at the end of the process, both houses agreed on the final version, and the Governor General gave roll assent. Now let's talk a little bit about the bill. Now the Fisheries Act, it may surprise you, is even older than the Indian Act. It was passed in 1868, 1 year after Confederation. It is one of the oldest laws in Canada. It hasn't changed very much over the years, which is very surprising. The first major amendment happened in 2012. Under the Harper government, the Conservatives amended the bill, in an omnibus bill, by the way. And what it did is that it narrowed the protections that was offered under the bill for fish and fish habitat. So prior to Harper, all fish and all fish habitat were protected by the Act. In 2012, the Conservative government narrowed that protection. And they basically narrowed it to Aboriginal fisheries, to commercial fisheries, and recreational fisheries. In other words, anything that was harvested in the ocean was protected. All other species, and there's a lot of species that are not harvested, basically had no protection. And so this made it easier to do major projects because it narrowed what was protected in the oceans. And that bill finally came into force in 2013. So in 2015, when the Liberals were in the campaign, they made it quite clear that one of their platform issues was going to be returning back to the protections that were previous to the Harper government. In 2016 and 2017, after they were elected, they went across the country, they conducted all kinds of consultations about the Fisheries Act, and the House of Commons itself, its Standing Committee on Fisheries and Oceans, also did a report. And this was the first real comprehensive review of the Fisheries Act. Every part of it was looked at. Many people commented on it. And finally, in 2018, what we now know as C-68 was introduced in the House of Commons in February of 2016. So what are the key parts of the bill? First, the Liberals had promised that they would restore the lost fish and fish habitat protections that were lost under the Harper government. The Liberals once again restored the protection on all fish and all fish habitat. So as I mentioned before 2012, all fish and fish habitat were protected. What's in the bill, it basically says it was illegal to kill fish by any means other than fishing. So you couldn't pollute, you couldn't put things in the water that would kill fish other than fishing, for instance. It became illegal now to destroy habitat, and it restored a previous protection called HADD, H-A-D-D, which is harmful alteration, disruption, or destruction of fish habitat. They restored the HADD provisions, meaning all fish habitat were protected once again. And the Harper government in 2012 basically limited the protection to 3 types of fishery, to commercial, recreational, and Aboriginal. So I'll come back to this point later on because it'll be very important. So remember that the previous provisions only were limited to those 3 fisheries. all other fishery and fish habitat did not have any protection. And the protection itself was really not very much for those 3 fisheries. It was basically reduced to what's called serious harm under the Harper Act. So, once again, under the Trudeau government, it was illegal to kill fish by any other means by fishing. It was illegal to do any work that resulted in HAD. Today, now major projects require a permit, and any minor projects now require a compliance with a code of practice. So basically, all the previous protections that were lost were restored under C-68. The other key thing in the bill, for the first time, was there was some detailed indigenous provisions in the bill. Now, in the previous bill, in the Harper government, there was a definition put into for Aboriginal fishery, which basically was restricted to food, social, and ceremonial. It was also restricted to land claims provisions. So, under C-68, the government introduced some new definitions. Introduced a definition of what an indigenous governing body was. It introduced a definition of what indigenous peoples of Canada were, which basically Section 35 of the Constitution, First Nations, Métis, and Inuit. And it introduced a definition for indigenous fishery. And I'll come back to that point in a few minutes. It also introduced a section called Indigenous Peoples of Canada. And there's 3 main provisions under that heading. So it introduced the rights of Indigenous Peoples of Canada, basically a non-derogation clause. It introduced 2.4, which talked about the duty of the minister when it comes to Indigenous rights. And then 2.5 is a list of considerations that the minister must take in making decisions. But let me first go to this one, because this one was a win and a loss at the same time. One of the witnesses that appeared before the Senate Fisheries Committee was Chief Terry Paul and Bruce Wildsmith. And one of the proposals that they had made was to improve the definition of indigenous fishery in the Act. As I mentioned before, it was basically food, social, ceremonial, and land claims. And of course, what about rights? And so this was the argument that Chief Paul and Bruce Wildsmith made. And the win was that almost word for word, what the Assembly of Nova Scotia Mi'kmaq Chiefs presented to the Senate was accepted word for word practically. So this was the definition that was accepted. It says, indigenous in relation to a fishery means that fish is harvested by an indigenous organization or any of its members pursuant to the recognition and affirmation of Aboriginal and treaty rights in Section 35 of the Constitution Act 1982, or for any purposes set out in any rights implementation measure as agreed to by the Crown and Indigenous peoples. And as I mentioned, this is a win and a loss. And I'll explain what the loss is in a minute. So quite clearly on the face of it, it would recognize the rights that the Mi'kmaq had won under Marshall. Okay? And I understood that. We understood that. But the problem was that this definition was very short-lived. When the Act came into force, August 26th, this definition disappeared. So they gave it in one hand and took it away on the other. And for the longest time, we argued this, and we've tried to understand the government's logic. And I have to admit today, I still don't fully understand it. But this is what they say. Under the Harper government, fishery was defined as only Aboriginal, commercial, and recreational. And under the Harper bill, they had definitions for each of those 3, right? So they had a definition for Aboriginal, for instance. But the Harper bill was only limited to those 3 fisheries. under the Trudeau government, they extended the protections to all fishery, whether it's harvested or not. They protected all fish habitat, all fishery. So when this bill came into force, those definitions were no longer required because they were tied to fish and fish habitat. So when this bill came into force, that definition disappeared. So that was a bittersweet negotiation, knowing that we were negotiating something that we all knew that was going to be repealed anyway, and it was repealed. Some of the provisions that did stick. This one here, again, the Assembly was quite vocal that the non-derogation clause, the clause that protected Aboriginal and treaty rights in the Act, had to be strengthened and improved. What was in the Harper, or what was in the first draft of C-68, was pretty weak. I had found out that the Senate had did a study on all the non-derogation clauses about Aboriginal and treaty rights were in government bills. And the one that was in C-68 was probably one of the weakest. And so through the Assembly and through others, we began advocating for a much stronger non-derogation clause. And the Inuit people from the north also were quite vocal on this. So what we end up adopting in the bill was probably the strongest non-derogation clause in Canadian legislation, and it was adopted here. And it reads, "This act is to be construed as upholding the rights of Indigenous peoples recognized and affirmed by Section 35 of the Constitution Act 1982, and not as abrogating or derogating from them." Now, probably for non-lawyers, it doesn't mean a whole lot, but for those of us who are very mindful of how our rights are being protected, we were quite happy with this. And I have to give credit again to the Assembly for advocating this, and also for the Inuit up north for advocating this. And fortunately, the government accepted this one. The other key provision in the Act deals with the duty of the minister. And the minister now has to take into consideration before he makes any decision about the rights of our people. So I'll read it. This is 2.4 in the Act. It says, "When making a decision under this Act, the minister shall consider any adverse effects that decision may have on the rights of Indigenous peoples of Canada recognized and affirmed by Section 35 of the Constitution Act 1982. Of course, the martial rights are Section 35 rights. So before the minister makes any decision on any matter, he has to consider the impact on rights. Again, we try to improve this. At one point, we made a proposal that the minister shall, and we wanted to put the word in consultation with Indigenous peoples, consider any adverse effects, but that particular amendment didn't happen. But right now, in the current provision, this clause bounds the minister, gives him a duty to consider the adverse effects on our rights. Now, there's other parts of the bill that are also important to point out. There's other Indigenous provisions, so we basically went from zero, and now we have a number of provisions in the bill. It includes this first point about advisory panels. The minister now is required to set up advisory panels, and here he made it quite clear that Indigenous people will be part of his advisory panels. Another important point in the bill was that the minister now can enter into agreements, and in the previous bill, it was basically restricted to provinces. And here in this bill, he can also make an agreement with any Indigenous governing body. So, for instance, here in Nova Scotia, we've been working towards RRAs, Right Reconciliation Agreements, on our rights. But once those agreements are finalized, where would they plug in to the Fisheries Act? And so this provision is to plug in. This is where those agreements can be plugged in. What we tried so valiantly, and again, we put up the good fight, but we also wanted to include moderate livelihood in this clause, in 4.1 sub 9. And we went back, and maybe I'm divulging some things maybe shouldn't be divulged, but in my role as a sponsor, as the lead senator in the Senate on this bill, I had the opportunity to meet directly with the minister and his staff and debate these things one-on-one and to bring proposals to the minister. And I did this with this particular clause as well as with the other ones. And so 4.1 sub 9, we had originally had worded that would include moderate livelihood agreements or rights reconciliation agreements. In the end, this is what we came up with. And it says, an agreement, this is what the minister under section 4.1, the previous clause talks about entering into agreements with an Indigenous governing body. And so one of the powers of the minister would be an agreement entered into under subsection 1, which is the previous sentence, must respect the rights recognized and affirmed by section 35 of the Constitution Act 1982. It's really weird, and I've talked to our negotiators here at the Assembly. It was really weird, but for some reason, the government of Canada hates those words, moderate livelihood fishery. They just don't want to see it anywhere, and they resist it. They will talk about Section 35 rights, and that's what they did here. They said, well, we'll recognize and respect Section 35 rights, but we can't say moderate livelihood. And I debated seriously whether or not I should die on the hill on this one. But I said, no, there's other things coming, so I let it go. And the last point here is very interesting. And there are some First Nations, especially of BC, whose laws are even better than the Fisheries Act. And the government allowed this provision where laws of an Indigenous governing body may supersede the Fisheries Act. So if we come to a point in our nation, the Mi'kmaq Nation, where we develop our own Fisheries Act, and if it's better than this act, then this provision allows our laws to supersede Canada's laws. The other big heading under the Fisheries Act is called Indigenous Knowledge of the Indigenous Peoples of Canada. And there's a whole section in the Fisheries Act on Indigenous knowledge. So, for instance, if the minister has to make a decision, he can consider Indigenous knowledge as part of his decision. And according to the Act, any Indigenous knowledge provided is confidential. Now, there's a couple of exceptions, and you always got to read the exceptions. Sometimes the party providing the knowledge to the minister, they will ask for a written agreement for that to be released, and that's allowed. If there's a written agreement allowing for its release, it can be. Or if there's a court proceeding, and then that knowledge would have to be shared with the court. But the initial position is that any Indigenous knowledge provided to the Government of Canada about fisheries is confidential. There's other parts of the bill I find very interesting. The one that always excited me right from day one when I first was briefed about the bill was this one. It was measures to rebuild fish stocks. In Canada, there's about 22 major commercial fish stocks in our oceans. And only 3 have rebuilding plans. And the other fish stocks do not. And I was quite surprised. I remember calling government witnesses to the committee and asking them that. They said, you meaning all of these commercial fish stocks and you only have protection and a plan for 3? And so in this bill, now there's measures to rebuild fish stocks. And now DFO over the next number of years are going to be developing plans on all of those fish stocks. So now there's hope that those fish stocks will not disappear, that there will be efforts, measures in place to protect, and not only protect, but also rebuild those fish stocks. So for us as a Mi'kmaq person, as Indigenous people, finally, they're protecting our brothers and sisters in the ocean. The other big change, it was very, very important for the fishermen here in Atlantic Canada, was the owner-operator and fleet separation policies. And sometimes you hear the word PIFCAF. I think it's Protection of Inshore Fishery Canadian, it's a long acronym I can't remember. But part of the difficulties were there was a conflict of interest. Fishers who are harvesting fish would sometimes sell to processors, and the processors would also own the licenses. So they could set prices. The fisher had no choice, had no chance to negotiate. If your owner says this is what you take, that's what you take. And so this policy came in I think 2007, 2008, where the owner and the operator of a fishing vessel had to be separate from the processors and the buyers. So this really saved the fishery, especially in the Maritimes. But the problem was only a policy, and the enforcement really wasn't that strong. And so what Fisheries and Ocean has done is they have taken PIFCAF, have taken these policies, and now they converted them into law. And they're now included in the Atlantic fishery regulations, and they can be enforced now. The other one I was glad to see was the minister now has the power to issue 45-day fishery management orders to address threats. And of course, we've heard all about the threat to the right whales in the Gulf of St. Lawrence. And this is where the minister now gets the right to intervene on a 45-day basis to issue orders to protect situations like that. A quite controversial one was the protection of cetaceans, whales, dolphins. There were two places in Canada where they were kept in captivity, in Niagara Falls, and also in the Vancouver Aquarium. The Vancouver Aquarium now has given up theirs, but the one in Niagara Falls is still keeping whales and cetaceans in captivity. So this bill, when it came into force, banned all that. So yes, those that are remained are allowed to be grandfathered, or they're allowed to be shipped out, but going forward, marine land, for instance, can't keep whales or dolphins in captivity. And this was something that actually a senator from Nova Scotia, Senator Wilford Moore, had proposed. And when he retired, Senator Murray Sinclair took up the cause. Another practice that is banned is called shark finning. I'm not sure if you know what shark finning is, but shark finning is the harvesting of just the fins of the shark, and is usually used in Asian cuisine. So a lot of restaurants in Toronto, a lot of restaurants in the West Coast were buying immense amounts of shark fins. And of course, once the fins are harvested from the shark dies, right? The shark can't swim, it just drowns. So I was surprised at how big this industry was, to the point where several species of sharks went extinct. So now this bill prohibits shark finning. One of the other big concerns was that the minister's decisions weren't transparent. So this bill now creates a public registry where all the minister's decisions and all the decisions made by DFO are now go into a public registry where individuals can actually see what those decisions are. It also creates a system of alternative measures for fishery offenses. And I think we in the Assembly have some experience with that. When there are individuals who are charged, instead of going to the court system, they can go to restorative justice, alternative measures. And this bill now allows for that, not only for Indigenous people, but for others as well. And the last thing was that we were quite happy that it won't take us forever to look at this bill. This bill has to be reviewed every 5 years. So what we didn't win on this round, 5 years from now, we'll get another shot at this. As I mentioned before, and this is my last comment, I was quite startled how DFO and the Minister of Fisheries were so adverse to talking about moderate livelihood fishery. And I argued this point over and over and over again. But it's just like showing the cross to a vampire. You talk about moderate livelihood, and they would go like that, right? And I think the minister knew, and some of us in the Senate, and there's about 12 Indigenous senators now, we were quite concerned about this. I clearly remembered April 30th when Chief Terry and Bruce Wildsmith came to the committee, to the Fisheries Committee. And several of non-Indigenous senators that are sitting on that committee were astounded at Chief Terry's testimony, that here it is 20 years later, and we still haven't had our moderate livelihood right recognized. And I think there was some sensitivity now in the Senate, at least, that we have to acknowledge or recognize or say something about moderate livelihood. So Chief Terry made those remarks on April 30th. On May 30th, and this was the day we began the final debate on C-68. So at the end of this debate, we have to say yes or we have to say no. And so the minister, Wilkinson, had this comment, had these words read into the Senate record. And this is the closest I can come to of finding anything that the minister or DFO says about moderate livelihood in the public record. He says, I make my commitment, this is Minister Wilkinson, to ensure that my department, DFO, moves forward on a path that respects Aboriginal treaty rights and the right to a moderate livelihood for Mi'kmaq and Maliseet First Nations as affirmed by the Marshall decision. So that's the best comment we have so far after 20 years. Now, who knows what the next 20 years has in store? Who knows what the next 5 years would have in store? But at least I can say today, on the 20th anniversary of this decision, that we are making progress. It's slow, it's frustrating, it's difficult, but I think Junior would have been glad to hear that some progress was made on the 20th anniversary in 2019 on this decision. So thank you very much for listening. I know this is complicated, but I appreciate the opportunity to share this.
We thank you very much. We have a gift for you too as well. Everybody take a picture. Wow, this is truly amazing. And it's a true honor to be here and to be part of history. Each day, from the very first day I walked into Membertou to being part of these great amount with great people from day one all the way to now, and to be among such great people in this room too as well. It's a true honor. I'm just speechless. Can you imagine me speechless? And on that, there's so much that was shared. So how about a big round of applause for all our guest speakers this morning? Jane, thank you so much. Walalan. I mean, when you give the insight and the words, Juniors, you could hear them, you could feel them. We thank you so much. Once again, thank you. Eric, if I ever need a lawyer, I'm giving you a call. Thank you very much. And also, how about another big round of applause for Senator Dan Christmas? As a mentor, but also he did something that was truly amazing here. Not only showed you the inside of Parliament, not only showed you how the government thinks, not only went through all the records to find that comment that was made and to show you the work that needs to be done, but also, most importantly, what he did, he gave you time for lunch. 6 minutes before 12. So give him a handshake, give him a thanks for all the great work he's doing. We're on lunch break, folks. There's lunch in the back. We're going to be here at 1 p.m. 1 p.m. sharp. We're starting right on time. So we're back on right to self-government at 1 p.m. So enjoy your lunch while you're here. If anybody's going to Tim Hortons, I take a large with 2 milk. Large coffee, 2 milk. Give shout out to our translator. Wala Lin. All right, cue the music. Cue the dinner music.
Grammarly does more than catch errors. With Grammarly, you can find